Good afternoon. I'm Dr. Liesl Bryant, one of the risk management advocates for the Trust, and I'm glad you're able to join us for today's Risk Management Roundtable entitled Responding Without Overstepping, Ethical Decision Making for Subpoenas and Third-Party Letter Requests. As a trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of the many benefits that our policyholders receive through the trust. I'm one of the 8 advocates, and I'm very excited to be joined by 2 of my other colleagues, Dr. Julie Jacobs and Dr. Stacy Larson. So we'll start today, instead of our typical opening, we will start with 2 brief slide presentations, one on subpoenas and one on third-party letters, both of which we get many, many calls on. And then, as always, we will turn to your live questions and let the conversation develop from there. So Julie, I'm going to turn it over to you.
Thank you so much. All right, let's jump in. My biggest challenge here is going to be to keep this concise. So I'm going to do my best. The starting question we're starting with here is I just received a subpoena for a patient's mental health record. What do I do? Don't panic. A little bit of outline or a little bit of background here. What is a subpoena? A subpoena is basically a legal process that compels people to provide information, and it'll give the court jurisdiction over the subpoenaed party or the records, and it allows action to be taken if the subpoena is not responded to appropriately. Generally, a subpoena is issued by an attorney's office. And the simple way to outline it is it's a request with teeth, right? So you can't ignore a subpoena, but you will not always comply with a subpoena. And we'll talk a little bit more about what that looks like. So we like to use Latin in the world of law for some reason. And so subpoena actually translates to under penalty. And it talks about, the fact that if you don't respond in an appropriate way, if there's no exceptions that apply, then you will have to provide the information or you face some kind of penalty. The examples of exceptions that might apply, there are technical exceptions, things like improper service, not enough time to respond, not a subpoena that's not from your jurisdiction. So those are sort of procedural issues. Or for mental health records and substance use records, the main exception that's going to apply in our context is asserting privilege on behalf of the patient or client. And so if you receive a subpoena and you don't have authorization in most states, that means you don't provide the information. Now, I just want to say right now a blanket statement about the variations from state to state. 48 of the states have very, very similar processes. California and Virginia have quite different processes. So when you hear me talking about needing a release of information, if you're in California and Virginia, that's not going to apply to you. We don't have time to really jump into all those details, but certainly if you're in one of those states and get a subpoena, give us a call to talk about how the process is flipped a little bit on its head. All right, come on, tech. There we go. Okay, so back to the types of subpoenas. And again, our Latin love is subpoena ducis tecum, which means under penalty you will bring with you. That's generally a requirement to produce records. It's basically saying we want this thing. Sometimes you have to appear and produce the records, but oftentimes you can produce in lieu of appearance. And then there's a subpoena ad testificandum. I can't believe I said that right. And that's for testimony. And that could be testimony at a deposition, or it could be testimony at a hearing. Now, those are pretty different animals. And so really quick as an aside, depositions, if you have a trust policy, you may have coverage to get an attorney to help you with a deposition. But that's not the case with hearings. But again, I have to not get too into detail as much as I might want to. But you all can ask questions after this. So what do you do? How do you actually respond to a subpoena? As I just noted, you might have coverage if it's a deposition subpoena, but even if not, certainly if you're a trust insured and you feel any level of discomfort in trying to navigate this yourself, call us. We get subpoena questions, I'd say every day. Each of us probably gets one a day that we're doing calls because it's really not something that's comfortable. Your standard psychologist who does therapy is not familiar with this world. And when we get something that says you are commanded to, we might think we're actually being commanded to, in spite of the fact that there are exceptions and we may not actually need to produce the information. So contact your liability insurance company, particularly if you want coverage or consultation. There are some rare situations where you may need to obtain your own attorney. I don't think that's standard, but there are some nuanced situations where that may be important. A first step is to determine if the subpoena is valid. If it's not legally enforceable, then you may not have to comply. Now, this is again, very, very state-specific analysis, but some of the basic questions you might have: is it from in your jurisdiction or from a different state? Is there sufficient response time? Was it served properly, or did they just tape it to a light pole somewhere outside your office? So those are some of the obvious things to think about. And like I said earlier, if it's valid, you will have to respond, but you will not necessarily comply. And then the other thing is to identify really specifically, what are they requesting? Is it documents? Is it testimony? Is it both? Is it records in lieu of appearance? So you actually have to read these things, even though they're pretty difficult sometimes to decipher. And that's where someone like one of the risk managers or your own consultant can help you kind of translate legalese into English. I do think that's half of my job these days. So other steps to take when you're responding to a subpoena, once you've got one and you've determined, yes, it's valid and I've got to do something. If it's a current patient, it tends to be pretty important to talk to that person, right? Tell them, let them know that you've received the subpoena, let them know what they're asking for. Talk about the risks of disclosure. And there's kind of a general list of risks you can talk through. The first being the obvious: everyone's going to see your record. Not everyone, but everyone in the court. And it becomes, a question of how sensitive is that information? Do you really want that to be discussed and disclosed in a court of law? You, as a therapist, can't control how the information that is disclosed is used or interpreted. So it could harm the client's case rather than help the client's case, which would have the ripple effect of probably harming your therapeutic relationship. So you want to tread lightly, particularly as a treating therapist. Our roles are so limited that it might often be a better idea for the patient to seek an outside evaluation, get expert testimony, get someone who can speak to the actual question, rather than pulling you in and potentially damaging the therapeutic relationship. And sometimes there are other specific things you want to talk to the client about in terms of risks and considerations. Now, remember, you're not giving them legal advice, right? You are just saying, hey, let's pause for a moment. Do you actually know what's in your record? Do you understand what you're authorizing the disclosure of? Do you want to review the record together? There's a lot of things you can do to help a client understand what it really means to allow that disclosure. To me, it's, the ROI is one thing, but I think it's an informed consent conversation. What are the risks, and why might you not want to proceed? So then if your client says, yes, I want to go for it, I want to release the information, have them sign an ROI if there wasn't already one included. And if there was one in the subpoena and it doesn't look quite adequate to you, have them sign yours. There's no problem with that. So you just want to have the basic information of what's going to be released, to whom, and why. If you have a minor patient, that adds the complication of who actually holds privilege on behalf of that minor. It is generally going to be the parents. If the parents are divorced and they share medical decision making, then you're going to want both parents to authorize that disclosure. You don't want to get in the middle of those. I'm sure anyone who works with minors knows those are delicate situations. So if it's not clear who needs to consent or authorize that disclosure, contact an attorney or your malpractice carrier just to get some clarity on that. You don't want to disclose and be wrong. If you can't locate the patient, or if it's a former patient, again, it's not a legal requirement for you to get in touch with the patients. If you feel like it's important to do so, you might want to contact the attorney. You can ask without disclosing anything. You can say, hey, I got this subpoena. Who do you represent? How did you find out about me? What are you requesting? You can get a little bit more information, but you wouldn't disclose information unless you have authorization to do so. If it's for a hearing and you don't have a release of information, you still have to show up. Okay, it doesn't absolve you of your responsibility. You would have to show up and assert privilege on the stand. Again, I am going to edit myself and not get into details in the interest of time. Questions if you have them later. Sometimes you may need to contact the court. That's not standard. If you think the disclosure may be harmful, there are some ways you can challenge that the disclosure or the subpoena, or limit the disclosure to some extent. So we'll talk a little bit about some of those options. But the bottom line is, you're either going to comply or you're going to challenge it. And if you comply, you're only going to provide the requested information and consider any limitations that might have been, perhaps they only want certain dates of service or something along those lines. Challenging the subpoena in our world generally means, like I said earlier, you're going to assert privilege. And so you would respond to the subpoena and attorney, and you would just indicate that you can't confirm or deny that you know the patient that's been named in that subpoena. All of your records are confidential and privileged, and they're only going to be released with proper authorization or a court order. Do this in writing. That'll be your written objection to the subpoena. And then you sit and wait. And if they want to go to court and fight it out and try to compel that disclosure, you'll get a court order that says you're going to send that information. So I'm going to stop there. I know there's so much. I could have talked for an hour about those slides, but that's not what we're doing today. So save your questions and we will be able to address those in a moment. Handing it over to Stacy, and if we have tech problems, we are just going to figure it out.
You are muted, Stacy.
When I took control, it took away the mute bar at the bottom, so I couldn't figure out how to unmute myself. Technology, my friend. So just a slight pivot. We're going to talk a little bit about third-party letters and some thought process, some things to consider when deciding whether to write or not to write those. I started off here with this is not an exhaustive list by any means, but these are a lot of calls we get. These are the different letters we are asked about related to child custody and welfare, capacity, emotional support animals, accommodations for education, whether it be college or elementary, disability, surgical readiness, fitness for duty, personal injury, citizenship support, workers' comp, sexual harassment. And these letters, clients could request from you that letters be sent to family members, to attorneys, to their medical doctors, to law enforcement. There's just any number of permutations that these letters could take. So being aware of all of those different sort of options, that it's not always the client requesting a letter for X. It could be any number of different things. So I just wanted to put that out there first. So some questions to consider or think about. Do you, as a provider, have to write the letter? No. It's important to know that there is no requirement to write these letters. We may feel a pull as a mental health provider to advocate for our patients, and that's valid, but that advocating could set us into a dual role. So it's really important to kind of consider, do you want to write the letter? And we'll talk a little bit about this, but it's oftentimes some of these letters may be outside of your scope or your competence to write. So there's no requirement to write these letters. I want to start there. If you are kind of considering writing a letter, then there's some things to consider. And I could have gotten into a lot more detail on all of these, but again, we are trying to be time limited. So first, you should really look at your ethical guidelines for your profession. You want to kind of consider the regulations and laws for your jurisdiction. Your own scope of competence, where your training is, what your role is. And then considering, as I said, that potential for dual roles between being a forensic psychologist or a therapist or in that advocate role. You really want to, under our ethics code, of course, as psychologists, we really try to avoid those multiple roles. And that's just something to consider. I mean, when it comes to ethics guidelines, you want to really avoid those conflicts of interest that can come up with sometimes writing these letters. And I'm going to do a little shout out to Dr. Jeffrey Youngren, who is a big fan of do not write the letter and has done a lot of work on this. But, I think giving people that caveat of saying you can say no, I think sometimes that's helpful to know. So if you're thinking about this, that's just some questions to ask yourself. Am I competent to offer any relevant information on the requested topic? This is a pretty broad question, but to kind of narrow it down a little bit, maybe you are seeing mom or dad for mental health treatment for a mental health condition, and they are going through a divorce, and they want you to write a letter saying how great of a parent they are. That's a little bit outside of your competency in that instance. You haven't evaluated their parenting style. You haven't probably assessed it. It might have come up in therapy, but it's probably not something that you can speak to competently. The same if a forensic opinion were to come up, like this individual is saying that they can't work and they want you to file disability. It's probably something that may have come up in therapy, you've discussed in therapy, but are you competent to make that forensic opinion? And that kind of leads into the second question of it, like considering, are you engaging in a dual role if you respond to the request? And by this, we mean you're a treating therapist, you are their therapist, and they ask you to do this forensic opinion type of work, this letter that entails that. You've now switched into a different role. You're now a forensic person, and it's kind of hard to switch back into the therapist role from that. So I always want to kind of make sure, and I get that there's confusion with advocate versus therapy, but I want to say that as therapists, we advocate for our patients to advocate for themselves. We try not to necessarily advocate for them or step into that role. If I do disclose information or opinion on a topic, what is the safest way to do so? This is getting back to sort of like HIPAA rules and things like that, like the minimum necessary, fact based on the topic, staying within your competence, within your scope of practice, within the scope of therapy that you've been doing with that individual. Could writing a letter open the door to further involvement in that external situation? Of course, it could. Writing a letter goes to attorneys, it goes to the other side. It's very possible that you're going to end up having to go to court or do a deposition or things like that. It's not 100% always going to happen, but you should be prepared and aware that that could happen. You could be opening the door to have to continue to do this, short-term disability, et cetera, kind of continuing to follow up on those things. If you provide information, how should I acknowledge limitations? And I think, yes, this is a conversation you have with the patient before you even agree. If you're thinking of writing the letter, these are the limitations. Do you still want the letter? When you're in the letter, these letters a lot of times are written based on only information from one person, right? They are very subjective. We don't have a lot of objective data that often comes in when we are a therapist. And so acknowledging that limitation in the letter, I think, is very important. And that could be an area that could get you into trouble. Could you get into trouble for disclosing information or giving opinions on behalf of other patients or other parties? So let's say you have mom in a divorce setting with the spouse, and she is saying all of these negative things about the spouse, and you write the letter in support of mom, and you include some of these negative things about the spouse. That could be opening yourself up for a defamation or libel or slander, because you really have to be careful that these letters only deal with the individual. You want to kind of leave other people's names out of them. You want to leave children's names out of them as much as possible. You really want the letter to be, if you're writing it, about just the patient. And this kind of the last question I have on here kind of goes back into that. Would writing the requested letter or providing information put you in a forensic role? And I think the forensic role is if you are opining on something, that kind of is setting you into that field. If you are writing a fact-based letter based on treatment, and this is exactly like very treatment summary, then that's a little bit of a safer realm to be in. But it's very easy to kind of be like, yes, I, as Dr. Larson, opine that this person cannot work, but we don't necessarily have the objective data or the competence to answer that question. So other things to consider, like I touched upon these a little bit, different clinical ethical issues. Obviously, these letters, a lot of it is reliance on self-report rather than objective data. Our own objectivity or judgment could likely be affected. This could be a person who comes in, you've seen them for one session and they're asking you to write a letter. That might impair our objectivity in wanting to work with that person. It could be a person you've been seeing for 10 years and they ask you to write a letter, and it might change the relationship. And your judgment might be impacted by that long-term relationship. There are no real guidelines or standards. So I think that's something to always think about. Consultation, call us, call your colleagues, get a lot of consultation about these things. And on the other side, there's always kind of, I don't like to say it, but there is a potential for malingering on the patient's behalf or secondary gain. Those are always things to consider and think about. And it's difficult to kind of engage in these roles without it potentially becoming a conflict of interest, depending on where things go. So all of those factors kind of argue for refraining from providing the letters or only doing it like with an abundance of caution. And so if you decide you must write the letter, and again, this might be a little bit of redundancy, and I realize I'm short on time. Do you have the competence? These are questions you really should ask yourself anytime anybody asks you to write a letter, any third-party letter, whether it be an attorney, a client, an attorney with client's authorization, etc. Do you have the competence, the authorization to provide the information? Stay within the scope of your role. You don't want to make legal determinations for your therapy clients. Providing only factual information, not opinions, unless that is your scope. If you are forensic and you have been hired to write this letter, and that would be different. But as a therapist, we're talking about providing the minimum necessary information to respond to the request. Again, do not discuss or opine on third parties in your letters. Don't disparage the other parent or use language that may defame. And then you want to make sure that you're really upfront with the limitations and risks with your clients. The client may disagree with or feel betrayed by your disclosures. This is why you would want to show the client the letter before you release any letters, and discuss those limitations with the client. And the client may be upset with you or blame you if they do not obtain their desired outcome. I think these are just things to kind of be aware of that are potential aspects of what could come up with writing letters. And with that, I think that is, let me look at my paper version. That is my last slide.
References that you will all have if you have the slides, and then I am going to stop sharing and we'll start the fun stuff.
Great. Well, thank you both. As always, you gave a tremendous amount of very useful information very succinctly. So we do have some questions, and I'm noticing we actually have fewer questions than we typically do at this point. So let me please encourage you. I know we're changing up the format, but we really do want this to be the discussion that we typically have. So please pop your questions into the Q&A. And remember, too, that yes, you can ask about what Julie and Stacy have talked about, but you can also ask questions that are not, that are related to professional topics that they didn't talk about. So if you have another question that you want to get some feedback on, please ask that too. All right. So that being said, here's a question on subpoenas. So Julie, I'll start with you, although I know both of you can answer them. The question is, in responding to a subpoena for records in workers' compensation cases, does the same process apply? This person has heard that privilege does not apply in these cases.
That's a really great question. And if you read our HIPAA Notice of Privacy Practices, which none of us really reads, but there is actually an exception for workers' compensation situations. I think the general concept is that when you file a workers' comp claim, you're waiving privilege. You're kind of saying, hey, you're going to investigate this, you get to look at everything and make your determination. That said, I never like to hang my hat on a HIPAA exception. If I get a request for workers' comp, I'm still going to talk to the client. And part of my conversation about the risks is going to be a little bit different. It's going to say specifically, if you refuse to allow this disclosure, there's a chance that your workers' comp claim is not going to go anywhere. So that's a different risk to add to the agenda or to the analysis. If I talk to a patient and they say, I don't want you to send it, even if it's a workers' comp claim, I'm going to honor that. I'm going to let them know that they are probably going to not be able to, they need to talk to their attorney or whoever is filing that claim for them, because there will be consequences to that. But I don't like to rely only on a HIPAA exception. Now, it creates a complication if it's a former client that you can't get in touch with. Technically, you can send that information. I would still be cautious and I would try really hard to get some kind of confirmation that that's what the patient or client actually wants. But sometimes there are situations where you just can't get the kind of information that you want. And from a purely legal standpoint, HIPAA does permit that. I would also probably ask the state to provide some sort of citation to authority that would allow me to disclose. I'd be, there's no problem with just saying, can we pause here for a moment before I start sending you stuff? You can always not disclose and be wrong and disclose later, but you can't undo it once you've done it. So I think we all take a pretty conservative approach on starting with a non-disclosure stance as best you can, but there are situations where you may end up sending information without having checked every box you might want to check.
Right. No, great answers. Stacy, anything to add to that?
No, I think that is perfect. I think there are a few different areas where there's those exceptions will come up, and I'm not going to get into those, but I think that's the questions that we do get often, how we play the two things apart.
Yeah, and I'll just underscore, right? I mean, consulting, if you're not sure what to do, give us a call, consult with other knowledgeable people, for sure. And I echo Julie's idea to be more conservative, right? You can't unring that bell once it's rung, so to speak. So Yeah, great question. All right, so here's another great question. Oftentimes they say, I will use Google or AI to help translate legal jargon. Is this a cheaper alternative? Or do you suggest finding a legal consultant to help translate legal documents? Stacy, do you want to start with that one?
So I think it's okay to use Google and AI sometimes to try to decipher legalese. That being said, if it doesn't make sense, I always would want to back that up and see if you can find somebody else. So in an initial, like, okay, I got this document. What does it mean? I'm going to type, subpoena duces tecum or whatever into, I can never say the Latin, into Google to see what it tells me. I think that's valid. I like the idea of trying to inform yourself initially, but you always want to make sure that you're confirming with a colleague or an attorney or somebody else. If it doesn't seem, you're like, it gave me this definition and that makes no sense and it doesn't line up. Or because as we know, AI, it can be both beautiful and terrifying. And so sometimes you're never sure what you might get out of that. So I view kind of using it as the dictionary. Like I figure I'm going to see if I can find it, but then I would want to verify. I don't know if that kind of makes sense, but yeah.
Yeah, no, I think so. Julie, anything you want to add there?
Yeah, I would, I don't trust but verify isn't even what I would say. Mistrust and verify. I have seen, my clients will send me something and say, this is what I put into Chat GPT and this is what it said. And some of it is blatantly wrong. This is permitted under HIPAA and it's not. So I really, really, I might use it as a very, very first step and just say, hey, okay, let me get a little bit of an idea about what this is. And then, as Stacy said, consult with someone. Please do not let that be your first and last step. It's just when something seems too good to be true, it is. And that's my first and final statement on AI, unless and until somebody else asks another AI question.
And to clarify,
Yes.
I'm not saying put everything in there. If you're looking
Mm-mm.
up terms,
Mhm,
that was the
mhm, yeah.
question I wanted to.
Translate
So
Latin. Yes, it can
yes,
translate Latin.
Well, and I love that phrase, mistrust but verify. I might borrow that at some point, Julie. That was very good. Two things I want to know, because I do think we have to be really cautious with AI. There's some great stuff, but it can be really wrong. And importantly, it can sound like it's really right. So
Mhm.
it can look right. It doesn't even necessarily look suspicious. I've sometimes used it to look up law, and it's like, yep, this is the statute in that state on minor, whatever it is. And it sounds like it knows it. And I ask for the citation, I go and look it up, and it's absolutely false. That's totally not what it is. So that, and then the other thing I just want to say is please don't upload the entire subpoena into public facing AI, right? Because that is a huge breach of confidentiality. You don't want any patient information put into the AI system. So just a word of caution there. If I agree with Stacy, what she said, if you're looking up a specific term, great. And as Julie said, mistrust and then verify. So, all right, great response. Someone asks here about the language to the objection. I know we're not going to probably put it in chat, but can you just repeat, Julie, when we're asserting privilege, what does that look like?
Yeah, I'll try to. I was probably talking fast because that's what I do. You're basically going to say, I've received your subpoena. I can't confirm or deny knowing the parties named in the subpoena. So you're not disclosing anything. And then all of my records are confidential and privileged, and they can only be released with proper authorization or a court order, not in California or Virginia.
Right.
But that's the general thing. And that is, considered from a legal standpoint, that is submitting a written objection asserting privilege on behalf of your client.
And then you've met your obligation to respond.
Yes, you are not complying, but you are responding. You can't just ignore it, even if you want to. And also, just don't, as tempting as it may be to try to hide from a process server, I have callers say, one of my clients is going to try to serve me and I'm just not going to be at the office. I'm like, well, then guess what they're going to do? They're going to hire a private investigator and they're going to show up in your house. So you're really probably not going to successfully evade a subpoena for very long.
Right. Terrific. Thank you. Stacy, I'll send this one your way. The question is, there are some pushy attorneys. Really? I've never seen that. No, I'm just kidding. There are some
I'm
pushy
not a
attorneys.
pushy attorney.
You're not, of course, no. Who claim their signature is an officer of the court and the subpoena and their signature serves as an order from the court. Do you have a recommendation on how to manage this?
Oh
Very clear.
my. Um, the only thing I can say is you need to stand firm in your understanding that they may be an officer of the court because they work within the court, but they are not a judge. And
Mhm.
judges are who sign court orders. I believe in all 50 states. I think there might be, I don't know, some wiggle room, I think in one state, but it wasn't an attorney. So attorneys are going to try to say that. And I hate to disparage my profession, but they want to get the information. They don't want to jump through a bunch of hoops.
Mhm.
So I think it's just matter of the fact saying, I recognize this is a subpoena. This is the rule for how we respond to subpoenas. This is not a court order because a court order will generally say court order and have a judge's signature. And so I think that's the strong one. Call us, consult us. We'll help you kind
Mhm.
of walk through it because there are attorneys that try to utilize their greater knowledge of the legal against individuals that don't in the hope that they can just get ahead, which is unfortunate and
Mhm.
kind of a bad side effect of being an attorney, I think, and going to law school.
Yeah. We get to talk about attorneys because we're attorneys.
Right. And we do
Yeah.
so with kindness and care.
With absolute, so I have actually a quick example of a situation where a paralegal was pushing, 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 and not because she was being a bully, but because she was just wrong about something. And it was a release of information that had a section about information to be released and a section about dates of the release. And under the dates, it said all dates of service, but they hadn't checked anything off in what to release. And this paralegal kept pushing back on my therapist client saying, you have a valid release. I'm telling you in my email what I want. I want the full record. You have a release that says for all dates of treatment. But she just hadn't checked the box on the form. And
Mhm.
so even if they seem very, very sure of themselves, it's not always bullying. Sometimes it certainly is. But you also want to stand strong. And again, that stance of non-disclosure, you're not, the odds of you getting a contempt of court citation like that, because it's just not it's not likely to happen that quickly. And you're not, and also you will almost never get a court order first. You'll almost always get a subpoena first. And then they fight over it, and there's a motion to compel the release, and that motion gets granted. So, yeah, try not to let it's easier said than done sometimes, but call us and we will give you a little bit of the ground to stand on and let you know where to draw that line.
Yeah, no, and I think consulting is really important because the other thing is you do not want to take advice from your patient's attorney.
Mm-mm.
Sometimes it's tempting, and I think some clinicians, if they don't understand the legal situation, will do that. Oh, here's an attorney telling me what to do. But that attorney is not working for you and protecting your rights, right? He or she is doing their job vis a vis their client. So be sure that we're not taking advice from patient's attorney either, and reach out. Okay, so here's another question. Does a treatment summary meet the requirements of a subpoena to provide records, such as a progress note? And I think, Julie, I'm headed
I think
back to
it's
you
my
on this
turn.
one.
I just
Yeah,
keep
I think
talking, so
so.
yes, no. If there's a subpoena for a treatment summary, which I've never seen or heard of, then that would be what they're asking for. But if they're asking for the record, they're asking for the record. And it actually is a great question because we will almost always say a treatment summary is better than the full record, just in light of the minimum necessary rule that Stacy referred to a few times. We always want to provide the minimum information necessary to accomplish the purpose. But in the context of litigation, I think that's the one context where a summary tends to be a worse idea. And the reason is because of our wonderful adversarial legal system. Part of that is the process of discovery, where both sides get to see all of the relevant evidence before anything goes to court. And so if you submit a letter or a summary, and they wanted the full record, or even if they didn't, so say an attorney is not very knowledgeable about this field and says, sure, a summary is fine. They take your summary, they try to submit that as evidence. The opposing counsel, if they are any good, is going to say, this summary of treatment is really cute. And if you think that is relevant evidence, the entire record upon which that summary was based is also relevant evidence. And so now I'm going to compel the disclosure of that full record. And then, just for fun, let's put the therapist on the stand with their summary. and their record, and let's pick them apart and make them feel super uncomfortable. Not that you've done anything wrong. A summary is, by definition, a summary, right? You had to pick and choose information to put in it, but they could really undermine your credibility on the stand if the summary is favorable and there's a bunch of unfavorable information in the record that you just happen to leave out. So, almost always a summary is a great option and a great way to minimize disclosure, except in this lovely world of litigation.
Yeah, that's a great point. Great point. Stacy, anything you want to add before I jump to the next question?
No,
No?
I think just kind of reiterating that there can be patient requests, right? And so that's when we can do the summary, but
Mhm.
subpoenas and court orders, yeah, no. And it gets to that sort of it's an unconscious bias, right? We draft up the
Mhm.
summary and the patient is our client, and so we put unconsciously we put all the good things into the summary, and like Julie said, then you get picked apart about why didn't you include this,
Mhm.
that sort of thing. So yeah.
Right. Right. And I'll add here too. I mean, there are some, I know there are practices that sometimes have in their informed consent that they will never release a record and they will only release a treatment summary. And we really recommend against that because, I mean, in some cases, it's not legal for you to deny the patient a copy of their record if they want it. So, wanting to work against that sort of myth that seems to be out there that it should always, in every context, be a treatment summary. But all right, so Stacy, I'm handing this one off to you. When writing third-party letters, sometimes I report information that I state the patient has told me, such as the patient reported on X date that the police were called to their home. I find this sometimes walks a line between a letter that the patient wants but keeps me out of the forensic role. Can you speak to some of the complexities of that?
No, I think that's actually perfect if you're going to choose to write the letter, right? It needs to be fact-based upon treatment. And because the information coming in is so subjective, when the patient tells you something, you want to attribute it to that. So, in that instance, patient reported that the police came to their home. If somebody is telling you they can't work, patient reports they can't work. I'm not saying they can't. They have told me they can't, and I'm reporting that back to you because that's in the record. It should be documented. These letters, you're not going to want to make up quotes or anything like that. Not that I think anybody would, but you still want to be able to support those statements with the information that is in your treatment record. So I do like the idea of making sure we attribute things to where they came from. Patient said this, patient's wife said that, depending on the type of letter that you're writing. I think that's a great skill to develop to be able to recognize when it should be maybe something coming from you, when it should be something coming from another, and a way to kind of protect yourself when you are writing those letters.
Yeah, great. Julie, any comments there? Any
No, I
additions?
think that's right on target. That's one of the sets of facts you have at hand, what the patient has said or what has been reported to you and by whom.
Yeah. And the only thing I'll add is I think it's also helpful to add a statement in the letter on your limitations that says something
Hmm.
like, I am this person's treating therapist only. I've not done an external eval, and my statements in this letter are based on patient self report and my observations in session. So it's really clear where your data is coming from. I think that's really helpful. All right, Julie, can you speak to the shift in attorneys' use of emailed subpoenas since COVID and how we should respond? So this is the question, right? Can they accept service via email? We get
Yeah.
this in a lot of different ways.
Yeah.
So go
And it's
ahead.
definitely a state by state thing. Again, I will say here in Colorado, where I live, you are able to send a subpoena by email if the recipient of that subpoena agrees to waive personal service. So you actually have to sign something that says, yes, I agree to receive this by email. But that's going to be a very state specific analysis. So I would say that as a general rule, and please correct me if you guys know any different, but I don't think that it is as a matter of course okay to just email a subpoena. I think there would need to be some, I mean, because the idea is the whole point of serving someone is to make sure they got it. And so if you just sent me something in my email and I haven't confirmed in some way, signing a waiver or somehow confirming I've received it, you don't know that I got it. And so you can't hold me in contempt of court for not appearing because you can't prove I have it. So it would be one of those situations where I wouldn't be so sure it was validly served unless there is some process in your state that allows for that. So that would be something it would be pretty important to consult on if you're not clear. But yeah, I mean, boy, they loosened a whole lot of rules during COVID, but I think pretty much all of that has been clawed back to some extent. And so now there are more options out there, but I still think there would need to be some sort of affirmative confirmation that yes, your email is in my box and I will receive it and I will respond to it.
I think there are a few states that will allow email service, but I don't know the specific rules about how and I think there's fewer of them, but yes, it's the state specific is important. Stacy, anything to add there before we move on?
No, I think that was, yeah.
Okay, great. So then I'll toss this one back to you because it's a little bit on the third party letters anyhow, but what are your thoughts on assessment for exam accommodations for students?
On doing assessments?
I think this here is
Maybe.
in the idea of a third party letter. If a patient comes in and says, say you've got a college student and they say, I want to get an accommodation so I can have longer on my
Okay.
exam. Will you, my therapist, write a letter? I think that if the question doesn't mean that, please write in and say, but I think that's what it's
I
about.
was going to
And
say, if you're doing the assessment and then your report would satisfy it. If you are not doing a formal assessment, then I would defer back to it's got to be fact based upon treatment. It's got to be the student reports this, and you never know. Like in some of these situations, you may, as a therapist, get access to previous testing records and things like that. And so there's an argument to be said that maybe you could include some of that information because it's part of yours in this, like the student was tested according to medical records, student was tested in high school, these were et cetera, et cetera. It's not necessarily information that you have. You would want to make sure that you're indicating that that came from a different area. But again, it goes back to that fact based and student reporting, like student reporting they cannot pay attention in class, or student reporting that their sleep troubles or making it that they can't stay awake in class, not that the class is super boring. And so kind of you still need to walk that fine line. But if you've done the assessment, then it's okay. If you're in that role, you are the assessor, then I think it's less risky to write a letter because you've done the objective data, you've done the assessment to kind of support the accommodations. I'm not sure if I'm trying to answer both questions if that's kind of where it was going.
I think you
well, I think
did.
Yeah, I think you did a great job. And I think what you're getting at is the issue of role. If you're the treating clinician and you're doing therapy, odds are you haven't done an actual assessment of the accommodation. So then you should write a therapy fact based letter. If you're an assessor doing an accommodation assessment, of course you can comment. I think that gets it. Julie, anything to add before I send a question?
Yeah, I think a lot of times when we get these calls that, our callers are they're upset or concerned about the impact of saying no to their client. Like, I want to help them and I can't help them in this way. And so as a way to sort of frame it, I think you just let them know that, I can't say you have a disability and you require this accommodation. That is something that a disability evaluator would have to do. But I can write a letter saying, I am your treating therapist. This is your diagnosis. You have reported that you do better when you have more time, or something like that. So trying to get the client to understand that it's not that you don't want to help, but your help has to look different. And, if it's not a formal disability assessment, there may be situations where a letter from a therapist just confirming that the patient has told them the same thing they're telling the disability office, that might have some value. It might not be without value, but you can warn them. You can say, I can't give you something that will absolutely recommend these accommodations. I can say that you have consistently reported these symptoms and that this accommodation helps you. And maybe the reader of that letter will take that at face value. Probably not, but at least you're trying to help. And I think that can help repair any rupture that might happen within the therapy room.
Right. No, great point. Great point. So this is not about a subpoena, but it is something we get a lot of questions on in terms of records request. And I'll let you start this one, Julie. What about responding to third-party company requests for records for the insurance company? It looks like can be third-party billed. I'm not sure what they mean by that. But basically, and we get many calls, right, as you know, on when a third party for an insurance company is requesting them on their behalf. Can you speak to that?
So it's an interesting question, and these insurance audits are really interesting. I mean, if you are in network with an insurance company, then you have agreed to provide them with the information they need to make determinations. The patient has agreed to allow the insurance company have the information they need to make determinations. HIPAA has an exception for payment. So, it's not so, if you're an in-network provider, getting a request from an insurance company is not so far out of the bounds of what's going to happen. Now, technically, if you're in network and the patient has, signed up for insurance, you don't need an ROI to send that information. That is actually an exception under HIPAA. As a courtesy, I think it's a good idea to talk to your patient about that request. I would try to tell patients at any time when I'm sending their records anywhere. And again, it's kind of similar to the workers' comp question. If the patient says, no, I don't want them to have it, you can say, okay, that is probably a breach of your contract with your insurance company, and they will almost certainly not pay for these services, and there may be other consequences to that decision. So you do your best to honor that and let them know that it's really kind of in this system not an option to get payment from an insurance company and refuse to let them see the records. Now, quick aside, there's this thing called a risk adjustment audit, and that is a different animal. That came from the Affordable Care Act. That is a data gathering mechanism that all insurance companies are required to audit a certain number of records per year for certain data. And those are not targeted audits. Those are not determination. They're not trying to claw back money. They're trying to meet their requirement as an insurance company to gather all this data. So if you get a risk adjustment audit, don't panic. It's really not about you at all. It's about the ACA and data. And so there's actually some good guidance from the APA on risk adjustment audits. If you look for that article, it can talk about what to send and what not to send. You don't necessarily have to send the full record, even if they ask for it. They are generally okay with a summary that has the information that they need. And you can just always assert the minimum necessary rule and start with a summary. If they want more, they will surely let you know. So I think that those are two pretty different situations, like an actual targeted audit for a determination about reimbursement versus the risk adjustment audits that are not quite so personal, I guess.
No, great answer. Great answer. Okay, Stacey, so I'm going to give this, and there's a lot of questions here that I think one of the major themes is where the clinician feels pressured by someone else to do something that maybe we wouldn't want to do or shouldn't do. So here's an example from an employer. This is someone who says they work for a hospital, CMHC. They often get requests for various types of letters, like the one you listed, Stacey, to help advocate for clients, to get resources, etc. How do you recommend balancing expectations of the hospital or the organization with her knowledge or confidence in her ability to do so, whether it's, whether she's competent or not, that kind of thing?
I think it has a lot to do with sometimes we have to provide education to the administration, to the individuals at the hospital, education about what our ethics code says about, competence and roles, and maybe, looking at these documents and being like, I can fill out section A because that's fact-based, but I'm not going to be able to do section B and C. And so hospital, can we figure out a plan, or is there something else that we can do? Because I don't think oftentimes hospitals and big organizations are doing this out of thinking we're going to stick it to this person. I think a lot of times they don't realize that as a mental health provider, you can't speak to everything that touches upon mental health. We all have our practice areas that we specialize in, where we are competent, where we are comfortable. I would never lead a DBT group. I'm evaluations all day long. And so I think we all have to make aware of that, and then being willing to kind of communicate that. Like our ethics code says, when there is a sort of difference between what an organization says and what we say, we try to make the organization aware of kind of those ethical issues, and see if we can come into some sort of consensus. I would say that's kind of what I would recommend in those situations.
Yeah, I think that's a great response. Julie, anything to add?
Yeah, just be the squeaky wheel, but be a squeaky wheel in writing so that you have a paper trail of the squeaking.
Yes. And I guess the only thing I'll add, and this is a little bit different than that context, but so often, right, we see clinicians who really want to help. It's our desire. Many of us got into this field because we want to help. And so but doing so in all circumstances, when that puts us beyond our roles, actually can cause more harm. And sometimes it can cause harm to the clients and to us. So I think that that unbridled desire to help sometimes needs to be checked. So I think, and that sort of fits with what you were saying, and broadens it a little bit. Okay, so Julie, I'll send this one your way. How do you suggest talking to clients who allow their records, including progress notes, to be shared, say in a some sort of context, either legal or here they say in a disability application? So they allow the records to be shared, and then they are upset or disappointed that something in the note disqualified them or maybe harmed their case in some way.
Yeah, I mean that's part of why it's so important to have that conversation at the outset and document it. Because if you don't document it, it did not happen. And so we can't stop people from making decisions that may not be in their best interests, but we try to give them the information they need to make a decision. And if they ultimately make what turns out to be a bad decision, you're not going to go say, "Ha, I told you so," but you are going to say, that's obviously very disappointing. And if you recall, we discussed that this is one of the potential risks of including your mental health record. It could very well lead to enough of a rupture that they don't want to work with you. And that's fine. And if they fire you and leave, you're still going to follow up and say, I have some referrals. I really want to make sure you get the care you need. I understand that you're upset at how that turned out. And to back up a little bit, to go back to the beginning of the process, that's a reason why reviewing the record together can be a good idea. So if, it's bad enough if it harms their case, but if it shocks them that it was in there and it harms their case, then they're going to be doubly upset or concerned. So, we don't love to sit down and go page by page necessarily through our records with clients, but if there's foreseeable harm, we do have an ethical obligation to try to avoid that harm, have the conversation. If they make a decision that ends up not working out for them, you will at least be able to feel good about the fact that you did try to give them that information. It's unfortunate that it went that way, and help them find what they need, whether it's with you or elsewhere.
Great. And I'm going to try to squeeze in a couple more questions here. We're getting close to the end of time. But Stacy, for you, because we get this an awful lot, this person says the most common request I get is for support for FMLA. Are the legal considerations for this the same as for workers' comp? Maybe you can comment a little bit on what to think about there for FMLA requests.
FMLA is a little bit different than workers' comp. Workers' comp means they're trying to that something happened at work and they are trying to get payment from work for whatever care they need. Whereas FMLA is they're asking for time off. That's a very general, explanation. I think, for FMLA, sometimes that's a little bit lower of a risk as long as it's fact-based. So you might have, we have psychologists that do peri and postpartum, specialize in peri and postpartum care. And they might have a patient who is dealing with some significant postpartum and needs a little bit more time. And so it's within their scope and they can fill it out. I think it's still something to consider when filling any of those out is sort of you want to have the broader picture, like the implications of that, how that could change if they get denied FMLA, what questions you can answer and what ones you can't. Because on
Mhm.
some of those forms, you're not going to be able to answer the questions. And they are generally a standard form that is just given to you. Here, complete this. So I think it's fine if you want to say to the person, I don't believe I'm the correct person. Why don't we talk about if there's another provider who would be more appropriate or how I can assist you without maybe filling this out. But it's sort of the same process, right? If you're comfortable with it, if you feel it's low risk, if you feel that the areas are within your competence, then it's okay to fill it out. If you are at all concerned, like they're asking you something about a psychotropic medication that you might theoretically know about, but not have the training in, then it's okay to say I don't have this information or leave those areas incomplete. But then talking to the patient as well about kind of what that might mean for their FMLA, sort of that
Right.
informed consent and staying within your scope.
Yeah. And also your competence, right? Some of those forms
Yeah.
have questions like what part of the job can they do? Can they do this
Mhm.
part but not that part? Can they do this if they get
Yep.
accommodations? Can they lift this much weight? Most treating clinicians don't have the data to answer those. So, great question. All right, we are We are pretty much down to the end. There's a quick question here that says, you have an example of what type of problems have resulted, say, from providing a pet letter or that kind of thing. I'm going to give you a quick tease, which is we do know some licensing boards have sanctioned providers for providing ESA animal letters. And a lot of it gets back to the stuff that Julie and Stacy have talked about today: competence, not having the data to support it, basing it only on patient self-report, etc.